Hello there. Nicola Sturgeon wants to have Scotland's independence voted on, if necessary, without London's approval. Now it comes to the place where the Supreme Court decides. Because in the conflict between London and Edinburgh, the British government continues to strictly reject a new Scottish independence referendum. The government's lawyer submitted London's written position to Britain's top court, the Supreme Court, on Tuesday. That's what a spokeswoman confirmed. Scottish First Minister Nicola Sturgeon wants her compatriots to vote again next autumn on whether Scotland should become an independent nation. In a referendum in 2014, a majority of Scots with 55% voted to remain in the UK. However, that was before Brexit, which the northernmost part of the UK had rejected with a clear majority with 62%. The supporters of independence therefore hope that the situation will change if there is another vote. Actually, for such a vote, the approval of the British government is necessary. That's the current thought on it. However, Sturgeon wants to hold the referendum in a lawful manner if necessary, even without this approval. Her government has therefore called on the Supreme Court to examine whether an advisory vote would be possible without the green light from London. By advisory is meant that a pro-independence victory would not automatically secede Scotland from the United Kingdom. The Brexit vote was advisory too, by the way. London is convinced that this would be illegal. It remains the UK government's clear view that a referendum on independence would be outside the legislative competence of the Scottish Parliament. That's what a spokeswoman said. The case is scheduled to appear in court in October. But let's talk for a second about the legal background for the UK Supreme Court's involvement in this situation they all rely on. For historical reasons, as a state made up of several separate jurisdictions, the United Kingdom does not have a single unified legal system. Instead, there is one system for England and Wales, another for Scotland, and a third for Northern Ireland, while they are still there. In most cases, the Supreme Court sits above all of these as the final court of appeal. The Scotland Act 1998, or the 1998 Act, created a right of review for the Judicial Committee of the Privy Council in relation to devolution issues. This jurisdiction was transferred to the Supreme Court upon the court's creation in 2009. Devolution issues may arise in civil or criminal cases, though some of what were previously devolution issues in criminal cases and that have now become compatibility issues under the 2012 Act. The list of devolution issues includes a question whether an act of the Scottish Parliament, or so-called ASP, or a provision of an ASP is within the legislative competence of the Scottish Parliament. An ASP or a provision of the ASP will be outside that competence and therefore not law, so far as it relates, among other things, to matters reserved for the UK Parliament or where it is incompatible with any convention right or at that time with EU law. The list of devolution issues includes a question whether an act by a member of the Scottish Government is or would be within devolved competence. The list of devolution issues includes a question whether an act or failure to act by a member of the Scottish Government is or would be incompatible with EU law, that was written 2012, or any of the convention rights. Insofar as any court finds a provision of an ASP to be outside the legislative competence of the Scottish Parliament, that provision is not law. A member of the Scottish Executive has no power to do any act where to do so is incompatible with any of the convention rights. But as far as I could look into this, I must say it is, from my point of view, more pro-Scottish government than UK government. But we will get the decision of the court soon. I'll see you in my next video. I'll be back.